There we are. Okay, so we are launching into part 2 of this relatively short CPD session. So the preamble, of which I'm sure, you know, I won't say any more about it, but for the longest possible time, I suppose I've had the pleasure and the privilege of studying our consumers. And I spoke to 24 of them. I've spoken to some of you about this before. And that was a long roundabout process. And in the end, I've finally written it up. And the process of writing it up, I guess it forced me to make some sense of some of the patterns that had been emerging. When you interview a lot of people, there's too much information. Most transcripts of an hour's conversation run to 50 or 60 pages. So, you know, whatever that adds up to, it's already a lot. So you have to try and code and use a series of codes to try and make sense of it all. And one of the themes that I stumbled on was the whole question of how do people who are doing simple procedure know about the law? Bearing in mind that simple procedure is intended for unrepresented people. Okay, it's cases a maximum of £5,000. Lawyers are by no means excluded. And some of you will know one of my hobby horses is the expenses trap, which cases between £3,000 and £5,000 have a separate set of rules, which are not very widely advertised, that do allow legal expenses to be recovered by the winning party if they've employed a lawyer. That's complicated. I'll not get into that. But other than that trap, it's fairly well set up for unrepresented people. And that, I mean, I'm wholeheartedly supportive of that. One of the rules actually says that the unrepresented people should not be disadvantaged. So these are rules for the sheriffs. So it's quite important that we understand that. So it was quite a natural question when I had about an hour to talk to people about their case. Some of them were our clients, some of them were Edinburgh clients. I can't remember which. I know which, but you'll never know which, and I'll not say. And that's kind of all quite a long time ago, all face-to-face, I have to say. It was before the pandemic that the interviews were done. But it came up quite frequently, the question of people's understanding of the law. And just in case you're thinking, well, what have I got to do with us? There are probably a number of ways of looking at this, but bear in mind, these people have either gone to the court or someone else has gone to the court against them, and the court has sent them to us. And at the tail end of the PhD, I eventually reached the conclusion that mediation in that context can be thought of as a justice ritual. And bye, Craig. Craig will hear some of this again. I think he's going to come to my Viva. So sorry, you've got to go. Yes, so I see it. I do think it's legitimate to say that what we're doing has got a relationship to the justice system in a way that some forms of mediation don't. You know, if I'm invited into a workplace and it's a mediation between colleagues, well, I think there's quite a strong case for saying the law may or may not have relevance to that, but sometimes none whatsoever. Or in community mediation, there are various settings, but I think in our setting, it's legitimate to ask. And I began to probe and I got some interesting answers. So this is by no means the heart of the PhD, but I'm going to present a little bit of my findings, and then I want to think through the implications of that for our practice. So I'm going to try and share my screen. Hang on, just checking the chat. No, none of that's to do with me. I'll close that. Right, where are we? Let's go from the beginning. Can you see a full screen now?
Yeah.
Lovely. Good. Hang on a wee second. I'm going to get rid of it. So there's always too much Too much stuff floating about at the top of these slides. Yes, so one of the questions, long before I did this study, and certainly long before I wrote it up, I'd noticed something that was repeated often enough for me to think, gosh, that's a pattern. So this would be students who I've largely taught, not always, there would also be people who've learned mediation elsewhere, and I might be observing or co-mediating, or be part of a mediation, or even talking about a mediation afterwards. And something would come up. Quite often it was something to do with a lack of clarity about legal rules or the system, not even the legal rules, what happens next. And the conversation would go somewhere along the lines of me saying, well, you've picked up there was a haziness, there was a lack of understanding. Did you say anything? And the answer would be, I didn't think we were allowed to do that. And I quite often think, well, who told you that? And of course, the answer must be me. But I'm not sure I remember that. And it's got me thinking. It's got me thinking that the materials, the wider culture of mediation is giving a message, I think, and I think it gave me the message when I first started mediating, that there's a way to do it. And anything that strays from that path is the wrong way to do it. And I think the way to do it, as I think you'll recognize from what I'm about to show, has a lot going for it, but is perhaps not the only story. So let's have a wee look. So I'm going to share some of my data. I may have shared some of this before, I can't now remember. But here's some of the things. So first of all, this is just a quick overview. Where do unrepresented people get information about legal norms, legal rules? Where do they get it from? And I found from my interviews 4 different places. There was their own understanding. Some got some information from the court. Some got legal advice. Some people do have legal advice. None were represented in the mediation, although by accident, 2 of the people I interviewed were actually lawyers. And I didn't bother not interviewing them. And actually, they were quite interesting what they had to say. So let's get into this so I don't take all the time. So the first source was people's own understanding, and I've slightly caricatured this as the law is on my side. That's certainly the vibe from some people. And I was also quite interested as a former lawyer to see that some people's recollection of the rules was pretty close to what the law actually says. For example, anybody can have terms and conditions. It doesn't make you not liable if you're not. Now, the Consumer Rights Act and various other pieces of legislation, actually, they do say that you can't impose any old terms on a consumer. And in fact, the courts have the power and will overturn unfair terms and conditions in some circumstances. So that was a woman who, I think it was the terms and conditions of a car park, who had damaged her car. So, she wasn't put off by being told, oh, well, you should have read the terms and conditions. And then there's another person, I just knew I didn't have a product I'd paid for. And again, some of you might recognize the kind of sale of goods type of idea in there. However, I'll just whiz on these 3 slides. There was also, in some people's case, they had an understanding of the rules, but perhaps a slightly hazy understanding. A little knowledge is a dangerous thing, as some of you might know. I've suddenly forgotten who said that, but I have used it in the doctorate. So there's somebody who'd actually, this individual had gone to 3 different sources of advice, lawyer and the CAB and someone else, I can't remember who. Nonetheless, had come away with the idea that it doesn't matter what the company says, and even if you get a year's warranty, you're fully covered for 6 years. Now, there's the germ of truth to that, but as you'll see from the next slide, there are some limits to that, but he wasn't aware of the limits. So it led him to be maybe more obdurate than he might have been. So that's parties understand. So that's one source. A second source I mentioned was from the court. Not so much of that, and I don't know, I'll be interested to know how much people are getting these days. I know some of our cases come from case management discussion and some don't. Some sheriffs, I think, are inhibited about giving information to unrepresented people. I've noticed this. And when you speak to sheriffs, they say, well, I don't want to give them the impression that I'm on their side or I'm against them too soon. They're actually more comfortable giving a heads up to lawyers than to unrepresented people, ironically, because one might think that unrepresented people are the very people who could most benefit. Anyway, here's some guidance. And that top one is it's the same person. The judge did the same, which was tell us we were wrong, made us feel small and said, you've had it 5 years. And that was the rub, that a 5-year-old sofa is a 5-year-old sofa. It has a value, and there's still an argument that it should be fit for its purpose. But you're probably not going to get a full refund of the new value of that sofa. Does that make sense? That's as much to do with the reasonable application of the rules as the rules themselves. And that's the sort of thing that people like lawyers and the CAB were saying. And the third source was the sheriff. The guy wasn't very happy. But another person was very positive about the input from the sheriff, focused it down to the two main issues. So that's the sort of thing. At the same time, we shouldn't underestimate one of the impacts of that input, that exposure to the sheriff. Particularly, I have to name some of the people who had been in front of some of the sheriffs in Edinburgh. Being recorded, I probably shouldn't say that, but were noted for being reasonably robust in their dealings, and you know, had a feeling that it was quite intimidating, and they didn't want to come back before the sheriff. And this particular person, I don't know if can anybody on the call tell me what did she say? The sheriff said it might be an idea to get the same judge, as there was another case involved involving the same sort of goods. And this person was saying, when I saw that judgment, I thought, absolutely not. What if he, the sheriff, takes a G against me? Does anybody know what a G is? I didn't. I had to look it up. There we are. Oh, somebody did. Sorry, yeah.
Grudge. Yeah.
Anyway, I've stuck it at the bottom. So it's an old Scots word, a good old word, a whim, a fancy, a caprice, a fit of sulkiness or obstinacy. So the person was nervous that the other judgment had gone against the consumer, that it would go against their case. So it's a double-edged sword, the input from the judge. Let's move on. What about legal advice? What about people consulting the lawyer? Well, there was 3 different categories. For some people, these were actually some of the business people. They thought it was a really good idea that the other party had legal advice, because some of them are quite familiar with the rules. And they were saying, well, you know, this former consumer of ours might not know, but the solicitor will know what the rules are. I think that was another sofa. I don't think it's the same one. But that's yeah, business people viewing it as useful to have legal input. Then there was other business people, because quite a lot of people who use simple procedure are small businesses, and they were really indifferent. Yeah, I had a lawyer, but in the end of the day, it's up to me. I'll do what I like. You know, and we shouldn't forget that that's a component of mediation, and you know, that's part of what we're about. And then finally, I thought this was quite an interesting example where, at least in one instance, the legal advice had just been really, really unhelpful. And this lady had inflated her claim on the lawyer's advice. The lawyer had said, "Oh, this will make the other guys sit up and take notice," and all it did was meant he put in a response, you know, and ended up having, you know, a big kind of Barney and being sent to mediation, something that could probably have been resolved by negotiation. So it was inflammatory rather than achieving what the solicitor wanted. let's move on, because this is what I'm really interested in. What about input from the mediator? This comes back to my question of what are we allowed to say and what should we say? So first I'll start, I've got 2 slides really of what I would call positive reports. So this is where people were telling me things that reflected well, or in their eyes. I mean, I have to say something that's in the PhD. I have to remember all the time that these are social constructions. People are telling me what they want me to know about what they want to present of what happened to them in mediation. So it's always through a glass darkly. So this is people's narrative reconstructed after the event. It doesn't mean, it's not the same as observing what went on, but it's an insight. So there's one, they were really good. And I tried a clarifying question. Was it legal information, as in like legal rules, or was it about the process? Exactly, yeah, it was more about the process. And I think I will repeat that. Information, for example, what happens if we don't settle today? What happens next? That kind of thing, that seemed to be both welcome and quite achievable, even if you're not a lawyer. It's not beyond most of us to grasp what's going on in simple procedure, especially if we get involved in more than a few cases. And then something I think we would all recognize, there's one example. Bear in mind, again, I think I would call this procedural information. Bear in mind, you probably need an expert report. Now, they said 500. I don't know. I'm not sure I know what an expert report costs, but it certainly, this particular individual was positive about this. It gave them pause. It probably made them more amenable to negotiating a settlement that didn't necessarily give them everything they might have got if they won, because they recognized there were costs and risks. And then there's somebody else, a more general point. And actually, I think at least 3 of my interviewees made that point, that after the mediation, or during the mediation, I grasped that I've got to prove things. And one guy said something about, oh yeah, and it's not just a matter of, oh, if the sheriff thinks I'm nice, he'll give me the money. That was like a revelation, which was quite interesting. So these are positive. And then some people went further, what I've called substantive input, and here's a positive take on it. So somebody actually, yeah, and this is more controversial. It sounds as if in this instance, the mediators intervened in a more substantive way and said, well, of course, by conducting these repairs, you've saved about £800 for future repairs and the cost of a cherry picker, because I think it was common roof repairs the person was trying to get back. Now, whether you think, well, that's to your taste or not, I don't know, but the person liked it. On the other hand, this could be done badly. This person was not happy. And the woman said to me, what made you think you could withhold her salary? It was an employment dispute. Now, in fact, I think that had an impact, but I think this is quite an important point in what I'm saying. The way this is done is also crucial. That was interpreted as abrasive by the particular person I was talking to, even though I think substantively was probably a fairly reasonable point to make, that there would, some sort of settlement would have to be offered. And in fact, a settlement was offered. So I'm not suggesting, you can probably pick up, I'm suggesting that some input can be helpful. That doesn't mean all input is helpful in all ways. And then this is actually taken from the famous Leonard Riskin piece, where he coined the phrase evaluative and facilitative. And under evaluative mediation, one of the things he talked about was general encouragement to settle. So this is not mediators saying, here's what I think will happen, but it is mediators saying, are you going to make a deal? And these are quotes. These are all quotes from interviewees. Okay, I'm now going to finish on a less positive evaluation, which will explain my conclusion. So the first one was a group of people who, they really picked up the idea that the mediators were constrained, that they didn't voice anything because it was against some sort of rules, which I've already mentioned. And this particular guy said, I would have liked some guidance, but they surely were not allowed to produce. And I think that's a bit of a shame. It's just an opinion, they should voice something. And in fact, this one didn't settle. And this person had gone to get legal advice afterwards and was amazed to discover, for example, that contracts, he learned about what a contract was, which he hadn't picked up from the mediation process or from the court, to be fair. Another interpretation people placed on mediator silence about procedural or substantive rules was that they were poorly prepared. I don't think they were quite polished up. There's a couple of other people said that, you know, I expected that they might know a bit more. And then finally, and this is probably the worst of all, for some people, yeah, quite a few, there was a sense of the mediators just not doing very much at all. And again, please bear in mind my caveat. This is a report to me. You know, I'm not saying this is accurate. I'm saying this is what someone told me. That they felt they were just message bearers. Going back and forwards, there was certainly nothing about, you know, consumer law, anything like that discussed with me. And a couple of other people said things along these lines. I remember one person I probed and said, you know, was anything particular that the mediators did? Anything particularly skillful? No, nothing skillful, not sorry. So yeah, for some people, now that might be because we're invisible. If we do our work really well, people don't notice us, and that would be a compliment. But I think what I'm glimpsing is the old facilitative evaluative debate influencing some of us. And that's a wee bit of what I'm concerned to impart today. And I want to have a conversation about it in a minute. And I'll just share a diagram which I devised quite a while ago. And this is really supposed to reflect mediating in the shadow of the court. We're not a judge, but we're a substitute. We're an authority figure. This is the kind of communication between mediator and parties that would be familiar to all of you, that the mediator will ask questions, but the mediator wants to prompt conversation between the parties. And if the parties do all the talking, that's usually good too. But I'm suggesting that what's really going on is there's a conversation revolving around a number of things. Not only the law, there's people's own sense of fairness, but there is what will happen if it doesn't settle. I think that's part of what goes on. And then there's also, how far can you go? There's often, you'll all be familiar if you do these cases with a period at the end where people haggle, they make offers, they reject offers. No, I cannot live with that. I don't care. I don't care what happens in the court. I'm not settling for that. So I'm suggesting all of these things revolve around, and that this leads to an outcome which we can fairly say is co-created. Not always with much input from the mediator, sometimes with more than others. And it's co-created by the parties and the mediator. And that, in a way, is my conclusion. That, I think, is what mediated justice looks like. And this is actually from the PhD. So I think this is very, very near the end. When the courts recommend or require mediation, this study shows it need not be a source of injustice. I'm very clear about that. Yet, the end goal of party decision-making will inevitably leave that possibility open, because we're not going to always stop people from making decisions that we might think are unfair or unjust. And that highlights the essential role for the mediator as a backstop against a settlement that shocks the conscience. I'm quoting from Ellen Waldman, who's written again recently, more or less suggesting that's a good role for a mediator. So I'll stop sharing at that. And that, oh, help my bulb. How do I do this? I've managed to lose my I've managed to lose my controls. That's interesting. I closed that. Oh, there we are. Jolly good. Okay, how's the time? Time runs away with me. Then we probably got another 15 minutes. What I think I'd like to do, actually, I'd like to put you in pairs and give you 5 minutes. Just chat to somebody about what I've said, because I think it's always interesting to get some other voice. I'm just doing this completely randomly. So I will create, I can't think, 6, 7 breakout rooms. You're going to be in a pair or a 3 with other people. Just have a chat about what I've said and discuss the implications. And then I'll bring you back in 5 minutes and we'll get some questions and comments. Okay, there you go. Actually, they're mostly 3s. No harm in that. There we go. Here's your invitation. And I'll pause recording. I'll just resume recording. Okay, thanks for indulging me there. And I see one question already. So Patrick knows the ropes. He's raised his hand. So either raise your hand or just stick your hand up. So Patrick, first of all, comment or a question?
Charlie, a comment, and I raised my hand because I need to get it in quickly. Like Andrew, I've also got a mediation at 2 o'clock, so I need to leave quite soon. But just, and I met in the breakout room with Adrian, and we were chatting about that. A thought that I've had, and it comes up from time to time, is, and I agree with everything that you've said about, us not being kind of just facilitative to the point of being completely passive. We need to be able to help the parties to know what to expect and to deal with issues. But I'm not sure that we always have that information available to us. And I'm not talking about legal issues. I'm not talking about what statutes say and what the law is on certain things. I'm talking more procedurally. And for example, and I'll try and be very brief, but last week I had a matter where the claimant was in England and I was doing reality testing and so on and so forth. And the claimant was essentially saying they intended presenting their case at court if it didn't settle, and it didn't, by way of witness statements. And if they couldn't present witness statements, then they would withdraw the action because they were third-party witnesses who they couldn't get to court, etc., etc. And I don't know whether that would be acceptable to the sheriff. I don't know whether you can present witness statements. Now, that's a simple question to put to the sheriffs, because they'll tell us in what circumstances would you allow a witness statement. I'm sure there are circumstances, but if the evidence is going to be in dispute, the other party can't cross-examine a witness statement. So I would imagine the sheriff wouldn't allow it. But we don't have those definitive answers. And what I wanted to suggest is that we perhaps compile a list of those kinds of issues and try and get guidance. We could go to the Judicial Institute and ask them if they'd give us answers to certain basic questions so we can give our lead mediators a little bit of background on what to expect from the sheriffs.
Thank you. I mean, I think that's a good idea, Patrick. I have to say, though, I think it'll never be comprehensive. It'll never cover everything. And what came out was people also appreciated it. And I think one of the comments touched on this, where even if the mediator said, look, I don't know what will happen, but I'm just flagging up, even to say, I have a vague memory that this might be problematic for you. Don't take my advice. Go and get that. They were fine with that, so you don't have to know everything to be able to, but you do, I think, probably have to have the confidence to act on your instincts or your hunches and misgivings. So I think we will never avoid a degree of, no matter how much you could still know it wrong. and lawyers can know it and still be overturned. I see Gordon has his hand up, so I'll turn to him.
Okay, thank you, Charlie. A couple of comments. One, first of all, thank you. I think that was really helpful and thought-provoking, and it's good to be able to sort of reflect on these things, as we all grow in our practice. And your diagram there about the co-creation, I think, is really helpful. In our discussion, we were probably struck by a few things. One being the number of times that people come to mediation in simple procedure specifically and still expect you to be an adjudicator. That despite the fact that they've been told that's not what mediation is, there's still that sense, and it can often be in terms of, I will send you all of this evidence And, you know, whilst they may not say the words out loud, it is that sense that, well, I'm sending you all because you know the rightness of my case and you'll decide for me. You know, so there is that aspect of it. There is also the sense that I've noticed and gives me caution in relation to giving any advice, and that is that the sheriffdoms don't always seem to behave in the same ways.
Absolutely. I think you're absolutely right.
Individual sheriffs will behave in quite unique and different ways. You know, we get referrals where I've certainly had a referral where the individual party didn't actually even seem to know that they'd been referred for mediation. You know, the conversation I had with them was the first that they knew about it. Now, that's their perception. That may not be true, in the same way that what you're talking about is, you know, that's what they've presented to us. So there are complications in there about one, about what it is that people's expectations of mediation are. Secondly, about where advice might be. One of the things I always do is to say, we are not here to provide legal advice. However, one of the things I will then often do is ask a question that will prompt somebody to go off and seek advice.
Yes.
Rather than giving advice, but recognizing that there are areas that are not for us to decide, but they're things that they should go and look for. So that was a couple of things, Charlie.
Well, thank you, Gordon. Can I just say two things? One is that it does come up quite often that getting advice, unless the lawyer's actually in the room, tends not always to be that helpful. It does tend to fuel confirmation bias. It's quite common for people to say, well, my lawyer tells me I've got 100% chance of success. That's a fairly common thing, and that came out. But the other thing, the conclusion of the PhD, one of the thesis conclusions is that it's a lower risk option for mediators to offer some input than none. And if the parties didn't want it or didn't need it, they were still appreciative. They just didn't bother. So, you know, on balance, I think that's what I've come out and said. It may not be needed, it may not be helpful, and they may ignore you, and that's all okay. So, but thanks for, I agree, and I think both you and Patrick make that point. Was there another comment? Thought I saw somebody. Tom. And we've really not got very long.
I think probably the intake is the place where advice can be usefully given to prepare both parties for things like Consumer Rights Act, or I've got a document I use, used car sales now, produced, which I gave to both parties, a trader and the person disputing is the car he got. And if both had read it, it became apparent. But I don't think they read these things very often. No. But giving them the ability to read these things before the mediation allows you to then discuss more reasonably between the two parties, I think.
Thanks, Tom. I mean, that's a great. I couldn't agree more. And I think that then gives you permission, if you like, to say that thing I gave you. Do you mind if we look at that without feeling like you're on somebody's side? You're simply confirming external information. So some key words, of course, will be A, don't take my word for it. B, you know, ask others. I mean, all of that. I think there are ways of doing this, ways of raising questions and question marks that people did seem to appreciate. You know, that I mean, I do want to give that quite positive message. Anyway, I'm really conscious we're going to run out of time, and I don't want to overrun past 2 o'clock. I've got a meeting at 2 as well. So thank you all. Well, this has been recorded. I'll stop recording in a second. And you're welcome to come back. And also, of course, welcome to come back to me. I still have a Viva. So some of this might still be revised and so on. But eventually, one of these fine days, if you're having difficulty getting off at night, there'll be a very long version of this. Anyway, thank you all, and
thank you.
See you around.